Good afternoon. Can that be heard? Good afternoon. I'm Emory Talbert, Chairman of the Department of History at Howard, and on behalf of the department, I want to welcome you all to the first Williston H. and Charles S. Lofton Conference on United States Constitutional History. Can't hear me? Okay, I'll talk a little louder. Our topic is Plessy versus Ferguson Revisited, Historical and Contemporary Perspectives. A great deal of work, as you might imagine, went into planning the conference, and I would like to thank, on behalf of the department and the university, the committee and the chairperson of the committee who put this together. Would the committee from the Department of History on the conference members stand for me just for 1 second? I know you're eating and... Yes. Dr. Edna Medford, Dr. Joseph Reedy, Dr. Eileen Boris, and Dr. David DeLeon, who did not stand, is there. Oh, he did, I'm sorry. And the chairperson, of course, Dr. Arnold Taylor, who you'll be hearing from later. Dr. Taylor put in many long, hard hours in organizing this conference, and we are grateful to him for it. More about that a bit later. I want also to give some sense of how this process began. You will have in your program a description of, or a brief few paragraphs on the Lofton brothers, who left an endowment for our graduate students, and also for purposes of conferences like this for the community, both the Howard University community and the community at large. I want to introduce the wife of Williston Lofton, who is here with us. Mrs. Lofton is right here, and we want to express our appreciation. Mrs. Lofton. Thank you. Mr. Charles Lofton will join us at a future event in this conference. The organizer of the conference, Dr. Taylor, as I said, worked hard, and he did not want to say much at this session, but he's going to end up saying a lot more than he had planned, because he has a little housekeeping to do, a few announcements to make. So I will turn the microphone over to him right now so that he can do what he had planned to do, and I'll be back later. Dr. Arnold Taylor.
Some of you were not at the opening plenary this morning, so to you I want to extend a welcome on behalf of the university, the College of Arts and Sciences, and of course the History Department. I would call your attention to our program, and we would want you to note the co-sponsors who are listed on the program. We are very, very grateful to the support, for the support of our co-sponsors. And then I'd like for you to turn, if you would, to a listing of the conference honorees. And I hope you have in your program brief biographical sketches of the conference honorees, and some of them are on the platform here today. Right now, what I would like to do is simply introduce the platform guests. And how do we do it, from left to right or right to left? Your left or my right? I'm going to start on my right in any case. First, I would like to introduce next to me Miss Debbie Roundtree. You can read about her in this little brochure on conference honorees. Ms. Lawson has already been introduced. Next to her is Mr. Oliver Hill. You should read about him also. And we'll have more to say about Debbie Roundtree and Oliver Hill later. And on the end is Professor Emeritus of Morgan Emeritus, Roland McConnell, who has always supported the department and is an alumnus of the department. On my left, you have met our chairperson, of course, Dr. Talbert. Next to him is the speaker for the occasion, Dr. Berry. And next to her is the dean of our law school, Professor Alice Bullock. And on the end is Professor Jack Greenberg, about whom you will hear more at this luncheon. So right now we will proceed with the program, and any other incidentals that we may wish to mention, we'll mention after Dr. Berry's presentation. Thank you.
As Dr. Taylor mentioned, our speaker for this occasion is Dr. Mary Frances Berry. She is the Geraldine R. Siegel Professor of American Social Thought at the University of Pennsylvania, where she teaches history and law. In 1980, she was appointed by President Carter and confirmed by the Senate as a commissioner on the United States Commission on Civil Rights. After President Reagan fired her for criticizing his civil rights policies, she sued him and won reinstatement in federal district court. In 1993, President Clinton designated her chairperson of the Civil Rights Commission. Dr. Berry has appeared as a guest on numerous television news shows, including Nightline, Crossfire, The David Brinkley Hour, Face the Nation, The Today Show, Oprah Winfrey, CNN, and C-SPAN. Dr. Berry is also one of the founders of the Free South Africa movement, which instigated protests at the South African Embassy in the struggle for democracy in South Africa. She was arrested and jailed several times in this cause. Dr. Berry was Assistant Secretary for Education in the U.S. Department of Health, Education, and Welfare during the Carter administration. As Assistant Secretary, she coordinated and gave general supervision to nearly $13 billion of federal education programs. Prior to her service at HEW, Dr. Berry was a provost at the University of Maryland, College Park, and chancellor at the University of Colorado at Boulder. Dr. Berry was born in Nashville, Tennessee, where she attended public schools. She earned a bachelor's and master's degree at Howard University, a doctorate in history from the University of Michigan, and a Juris Doctor degree from the University of Michigan Law School. She is a member of the District of Columbia Bar. Dr. Berry has received 24 honorary doctoral degrees and numerous awards for her public service and scholarly activities, including the NAACP's Roy Wilkins and Image Awards, the Rosa Parks Award, and the Southern Christian Leadership Conference, of the Southern Christian Leadership Conference, and the Ebony Magazine Black Achievement Award. She is one of the 75 women included in I Dream a World, Portraits of Black Women Who Changed America. Siena College Research Institute and the Women's Hall of Fame designated her one of America's Women of the Century. Dr. Berry's 6 books include Long Memory, The Black Experience in America, she co-authored with John Blassingame, The Politics of Parenthood, Child Care, women's rights and the myth of the good mother, and Black Resistance, White Law, a history of constitutional racism in America. It's my deep pleasure to introduce to you Dr. Mary Frances Berry.
Thank you. Thank you very, very much. Thank you. I am always pleased to be on the campus of Howard University. I'd come back anytime to teach you. You folks decide you want me. But I'm always happy to be back. And I am happy to be invited to speak during this Williston and Charles Lofton Conference on U.S. constitutional history, and to be up here on the dais with so many distinguished people, including Dovie Roundtree, who is one of my heroines, Jack Greenberg, who was once my lawyer, as well as being one of the leaders in the fight for civil rights for African Americans in the court. All of these distinguished people, Oliver Hill, and scholars like Roland McConnell, and the widow of Williston Lofton, who is here today, and others, the faculty here from the university. Dr. Lofton taught me constitutional history here. I was in his class here at Howard, and unless they moved the chair out of the room where we had class, one day when I was bored, I carved my initials in the back of the chair, so they may still be there unless the chair is not there. And I have fond memories of him, and I went on to become an expert, I suppose, and to be trained in constitutional and legal history, which is what I worked on at the University of Michigan, where I got my PhD. And of course, I teach legal history today. So Dr. Lofton had a profound influence on me, and I'm just happy to be invited to speak in a conference that has his name and that of Charles Lofton. And to talk about Plessy against Ferguson, 100 years later. Courts, like the court in which Plessy was decided, are venues in which people tell stories. Judges and lawyers bring stories into the court, and they talk about rules and stories based on thousands of years of common law. But there are other people who have stories too who come into the court. There are the litigants, the plaintiffs and the defendants, there's the jury, there are the people who are the witnesses. They all have their stories. And out of that complex of stories and the rules all mixed up together, you get decisions of courts. We have to keep that in mind so that we understand the impact of people's life experiences in courts, and that we're not simply talking about black letter rules that are unchanging over time. And so when we look at Plessy against Ferguson, we must keep this point about stories in mind. Houston Baker, who was another alumnus of this institution and who teaches with me at the University of Pennsylvania, says that, quote, "A war is in progress against black America. A war is in progress against black America." I think he's probably right in a sense. Houston is, of course, in English literature, and he may phrase things differently than I would, but there is a kind of war. Need I remind you of the symbols in that war, whether we're talking about the issues concerning Texaco, the riot in St. Petersburg and the police killing there, the Gamage, the acquittal yesterday of the police involved in that incident, police brutality around the country, the fallout from the O.J. Simpson case and then the second case, and all of these issues about race which are polarizing in this country. And in this climate, the case in which the Supreme Court endorsed separate but equal may seem to some people like a relic tossed on the trash bin of history. But Homer Plessy had a story, and he was as much a part of the black protest tradition as Rosa Parks, who sat down on the bus in Montgomery, and people forget that. Homer Plessy was part of an African-American citizens committee that chose him deliberately to challenge the segregation law. After he lost, the 14th Amendment, of course, became the refuge for corporations instead of African Americans, until a brief period in the years after Brown. Today, the 14th Amendment is the refuge of whites who accuse African Americans of discrimination against them. The strange odyssey, the story of Plessy, underscores the African American predicament. Our history is mostly survival in defiance of law and not because of law. And the case that bears Homer Plessy's name still illuminates the path of our struggle, our victories, and our defeats. John Blassingame and I, in long memory, called the Supreme Court's Plessy decision one of the killers of the post-emancipation dreams of African Americans. That was one killer. The second killer was the Republican Party, which turned its back on African Americans and decided to build up a lily-white wing in the South, and then in Washington did nothing to stop the oppression of blacks in the South. The third killer we talk about in the book was scientists who used Darwin's theory of evolution to rationalize scientific racism, which was consistent with the majority opinion in Plessy. In 1996, we have some new killers of the dream. 1 in 3 African American men are ensnared in the criminal justice system. Over half of black children live in poverty, and drugs are infused into our community to spread death by AIDS or violence from somewhere else because they don't grow in our community. Police violence occurs everywhere, and the offspring of Jim Crow Jr. works to confine opportunity for African Americans. The Supreme Court and the Congress and many state governments are as hostile as they were in 1896. The Republican Party, need I mention it, the Republican Party's Southern strategy to attract white racists to the party to win in the South has burgeoned nationally. Hereditarian racists, such as Charles Murray, reworked the same old theories into bestsellers, insisting that we are too inferior genetically to benefit from opportunity when it is presented. In 1996, African Americans are certainly better prepared for the struggle than we were in 1896. Much of that progress is due to the 1950s and 1960s civil rights movement. We have greater literacy, more assets, stronger black colleges and universities, and the right to vote and run for office. In 1896, we were blamed for our subordination. We were defined as ignorant, lazy, or unfit. Today, we are still defined as less intelligent, hardworking, and able than we are, and we are also blamed for our own predicament and for problems that exist elsewhere in the society. African Americans are among the convenient scapegoats for America's social and economic problems. After the turn of the century, African Americans had white corporate supporters of black colleges who gave money and built buildings and served on boards, and we also had progressive supporters who organized the NAACP. In today's consensus, many white liberals and black and white conservatives blame a lack of values among African Americans for whatever social problems we have. My belief is that even with ever larger percentages of immigrants coming into this country, and even immigrants of color, be they undocumented or legal, the race problem in America still centers on African Americans. Because of our history and present predicament, we remain the issue. Other immigrant groups try to distance themselves from us. Everywhere in the world, everyone knows that African Americans are the American other, the largest indigestible mass in the American intestinal system. That doesn't go away no matter how much Pepto-Bismol you take, or Tums for your tummy, or whatever. And you can travel anywhere in the world, as many of you have and I have, and you find people distancing themselves from African Americans. I spent a lot of time in Japan, and I have people tell me, well, we know that in America, the Negroes or African Americans, you colored people are inferior. We don't want to have anything to do with you. We see it on TV, we see it everywhere. You have all these problems, and when immigrants come to this country, the first thing they're taught, even if they don't know it when they come, is that you don't want to identify with African Americans. Even people from the Caribbean, you know, who are blacker than I, feel the same way, and not because they're racist, but because they know that we are the other. So some people get accents overnight sometime that they didn't have before. In the 100 years since Plessy, Justice Henry Brown's majority opinion and Justice John Marshall Harlan's dissenting opinions have both been implicated in the African American struggle. Most of us have never been integrated, and we were not desegregated after slavery, or when successive waves of new immigrants began assimilating into American society. Neither were we really desegregated during the civil rights movement. If you look at our history, we have tried everything. Coalitions with whites, we tried the NAACP and LDF and CORE and SNCC, and we've tried Charles Hamilton Houston and Thurgood Marshall and Jack Greenberg and Roy Wilkins and Martin Luther King, and we tried to gain reparations and Garveyism and the Black Muslims and Malcolm X and the Panthers and Karinga's Us and the Republic of New Africa and Farrakhan, and yet empowerment remains elusive for us. We've tried migration up north and then later out west and then back south again, and still we are harmfully affected by the persistence of racism, and our quest for empowerment through community solidarity remains problematic. Justice Brown's opinion in Plessy merely expressed conventional legal wisdom in 1896. There was nothing extraordinary about his opinion. Jim Crow prevailed well before the legislation passed after Plessy. Also, judges and lawyers had already decided that the 14th Amendment did not accord blacks social equality, which could only be had by consent and not through law. For years, Brown's majority opinion denying Plessy's plea has been easy to denounce. It has been one of the most denounced opinions in American history, and it's easy to denounce. Brown criticized Plessy for thinking that enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, he said, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. If the two races are to meet upon terms of social equality, including in theaters, trains, cars, or having business relationships, quote, it must be the result of natural affinities, a mutual appreciation of each other's merits, and a voluntary consent of individuals. The law could not touch these. Now, it's easy to denounce that. All of us could, gather together as people have over time and said, ridiculous, outrageous, terrible. However, what we don't often say is that Brown's views are consistent with Booker T. Washington's 1895 Atlanta Exposition speech, in which he denounced agitation and said to whites that, quote, in all things that are purely social, we can be as separate as the five fingers, yet one is the hand in all things essential to mutual progress. First time I heard that, Rayford Logan did that in class, said that. He was a professor here at Howard who taught me years ago. Furthermore, some African Americans today believe what Mr. Justice Brown said, that voluntary separate development offers a promising avenue for empowering African Americans, and that that's what we should have. I'll give you an example. Robert Woodson, who is at the Neighborhood Enterprise Institute, asserts that he participated in the civil rights movement to gain choice, not integration. He insists that African Americans should be able to choose a good black public school rather than trying to desegregate. Who would be opposed to that? Legally, this position seems remarkably similar to Justice Brown's opinion. Blacks, if this is correct, could sue for equal facilities, salary equalization, and even equal per pupil expenditures in public schools. We could also sue for access for public employment, public housing, transportation, and parks, if you use this analysis. Now, Justice Clarence Thomas, about which I will say nothing evil this morning, although I spend almost every day denouncing him for months, and then I just got tired of denouncing Justice Thomas. In any case, and I will do it now whenever it makes me feel better, but Justice Thomas expressed a similar view to that of Mr. Justice Brown and that of the one I've just described in the 1995 case of Missouri against Jenkins. He joined in allowing Kansas City to end desegregation and a funding plan for racially isolated black schools. Racially isolated, of course, just means mostly segregated. That's what it means. It's a polite way of saying that. Thomas announced that before the 1954 school desegregation decision in Brown, and I'm quoting, of course, segregation additionally harmed black students by relegating them to schools with substandard facilities and resources, but neutral policies such as local school assignments do not offend the Constitution when individual private choices concerning work or residence produce schools with high black populations, unquote. Therefore, racial separation in public education, he said, is not inherently unequal. But the Brown case was wrong. It's not inherently unequal. However, when separate but equal as a legal principle prevailed in the years after Plessy was decided, African Americans discovered something very interesting, that the Plessy decision by Mr. Justice Brown was never meant to make us equal or to afford equality of opportunity for a quality education or anything else. And frustration with all those years of trying to enforce the equal part of the separate led Charles Hamilton Houston, Marshall, Greenberg, and others to attack separation. That's why they did it, because, you know, it didn't work. Choosing separate schools as a possible way of gaining quality education in 1996, right here in 1976, is as fraught with difficulties as earlier. The record in the Kansas City case showed that the black children's schools were in dismal shape, that was what the desegregation order was for, and also if you don't believe the schools are in dismal shape, you should go visit some of them. And if you don't feel like visiting them, then go read Jonathan Kozol's Savage Inequalities, which is a good book, which shows that along with crime and discipline and substandard facilities and buildings crumbling and water coming through the roof and a lack of good textbooks, or even some textbooks, and inadequate funding and a lack of leadership by people who are not committed and who are worried about their own perks, all of these things uniformly plague all black or racially isolated schools, all of them taken together. Now, separate and equal. Some people argue that what we ought to go back to is separate and equal in 1996. That is what we ought to do. To go back to Plessy, say we want separate and equal, and try to get the equal part. Well, I don't think that's an achievable option. Why do I think that? It is undermined by the 1992 Mississippi higher education desegregation case, Fordyce against Ayers. The Supreme Court acknowledged inadequate resources for black public colleges in Mississippi, but then Mr. Justice White said that, you know, the state doesn't have to fund these schools adequately or even equally. He said because the former de jure segregated system of public universities in Mississippi impeded the free choice of prospective students, the state, in dismantling that system, must take the necessary steps to ensure that choice now is truly free. Then he went on to say, this does not mean black choice. And then I quote, if we understand private petitioners to press us to order the upgrading of Jackson State, Alcorn State, and Mississippi Valley so that they may be publicly financed exclusively black enclaves, we reject that request. What he said was that you could have neutrality, the schools could stay, but they didn't have to be funded adequately. They could still be separate and unequal. Justice Thomas concurred in this unanimous decision in the court. Now, in 1996, beating up on Justice Brown, as I said, is very easy. But what I'm about to do is do something that isn't easy and that most people don't understand why I'm doing it. In 1996, Mr. Justice Harlan's dissent in Plessy, I think, presents just as many problems for African Americans as Brown's majority opinion. It is just as problematic, not because Mr. Harlan intended it to be, that's not the point. But the point is using his opinion is pernicious and insidious and is problematic for African Americans. Remember, he said, in view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law, and so on. However, right before this quote is something that people never read, almost never read. I can't get students to read it. Right before this quote, he says, he assures white America that nothing he says is threatening their power or their status. He says, the white race deems itself to be the dominant race in this country, and so it is in prestige and achievements in education and wealth and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. In other words, if white America enforced the principle of color blindness, it need not fear African American progress, equality, or power. That is very important. That color blindness didn't mean that white Americans should fear that they would lose their power or that African Americans would become equal. All they had to do was use the principle and move on. Now, when Harlan died, African Americans were in despair. The historical record shows that black people cried, they were at the funeral, they were crying, and they wept because they said color blindness was most likely to lead us to the promised land. And in 1896, and when Harlan died, that seemed to be the case. African Americans and their friends who sought equality in the courts argued color blindness and had been arguing it since the earliest abolitionist days. And they argued it because it seemed to be a weapon that they could use to win. After the NAACP was founded, civil rights lawyers, including the whole panoply of them I've described, used Harlan's opinion to assail segregation. They used colorblindness because they wanted remedies. One of the things you have to remember is that while the law consists of stories and their impact on rules, lawyers are in the business of finding remedies. I mean, lawyers aren't just trying to find something to do, an argument that sounds intellectually stimulating. What they're trying to do is win, persuade, interpret to persuade. Civil rights lawyers use colorblindness because it seemed like an argument that they could use, and it did work, to win opportunity for African Americans, which is what they were trying to do. But soon after Brown was decided in '54, the limitations emphasized by Harlan in his argument, in the argument from colorblindness, became very apparent. The civil rights movement didn't do the job. Equal opportunity for many African Americans remained out of reach, and the window of opportunity briefly opened by the civil rights movement and the colorblind principle slammed shut. Many schools remained segregated and unequal, and employment and business opportunities remained limited. Civil rights lawyers began to differentiate between arguments against discrimination against us and affirmative remedies which might take race into account. In other words, they started looking for more remedies. And the Civil Rights Act of 1964 responds to this distinction. And so civil rights advocates said, we want colorblindness, that's the goal, but we have to use remedies for discrimination which will use race to get beyond the effect of racism against African Americans. Or for that matter, use sex to get beyond sex discrimination against women. And what happened? When they started making those arguments, from then until today, civil rights proponents have been assailed by people who said it was all right to desegregate lunch counters, but what are you people talking about? You're talking about getting the best jobs and educational opportunities, and you're being inconsistent, and you should stay within the limits of Mr. Justice Harlan's colorblindness. We thought you guys liked Mr. Justice Harlan's opinion. Why were you crying if you didn't like it? So you should stick with it, because after all, it's black letter law, and you've got to stick with it. And so civil rights advocates made the arguments that they needed to make. People who had never met a merit standard themselves got up in court making arguments about merit. They never met one themselves, wouldn't know what it looked like if they saw one. Blacks who were trying to desegregate schools were confronted with white flight and the complaints that the problem was not desegregation but busing by people who sent their children to school every day on buses to mediocre white private academies established to avoid desegregation, with a sign on the side of the bus, moderately mediocre private white school. The child get on the bus to go there to avoid black people. This opposition and the insistence of overbusing African American children killed any attempt to desegregate schools. And since 1965, colorblind jurisprudence has been increasingly a stalking horse for black exclusion. We saw that in the Proposition 209 debate out in California with this rather benign language, which is a stalking horse for black exclusion. And civil rights lawyers were not being inconsistent. What they were doing was seeking remedies. The other thing that's used against us is Martin Luther King and the lawyers. Martin Luther King believed in a colorblind society. They had this ad out there during the 209 debate showing Martin Luther King in a context that made it look like he was against affirmative action. Coretta had to write a letter to the New York Times or something explaining what everybody who can read and who has ever read Why We Can't Wait ought to know, which came out after the March on Washington, that Martin Luther King supported both affirmative action based on race and affirmative action based on poverty, because he understood that the problem was we needed remedies for the exclusion of people, and not that we should worry about whether we're being true to Mr. Justice Harlan's whatever. And that he had said in the March on Washington that the goal was colorblindness, not that, everything was colorblind in the first place. Now, today, some of the most important people who use colorblindness for nefarious purposes are sitting there on the U.S. Supreme Court. And we would hope that something would be done about that fairly soon if the opportunity to make some new appointments ever comes to pass. And it is, again, Mr. Thomas and the rest of the people there. When they explain things like why we don't need black majority districts, Sandra Day O'Connor said in Shaw v. Reno, racial classifications of any sort pose the risk of lasting harm to our society. They reinforce the belief held by too many for too much of our history that individuals should be judged by the color of their skin. Well, everybody would agree with that, but the point is remedy. And what do you do to remedy what has happened in order to create a context in which you can reach for color blindness? So the practical result of the use of colorblindness as a cudgel is to perpetuate the advantages of those who have been prospering from the use of everybody's tax dollars, getting all the contracts and everything else. Similarly, those who have suffered from underemployment and unemployment, glass ceilings and sticky floors and no government contracts remain disadvantaged. Lawyers on both sides have made clear to the court that their formulation of colorblindness means that government can never make a policy that takes race into account, even to remedy its own invidious discrimination on the basis of race, that's what the jurisprudence amounts to. Mr. Justice Bradley asked in the civil rights cases when African Americans will stop being a particular favorite of the law. The answer is his question is ridiculous. We have not been the favorite of the law ever, and so long as we use colorblindness in an invidious way and its brothers and sisters the level playing field and not by the color of their skins and only the content of their characters, in the law we will never be. The overall lesson of Plessy today is that the example that's given to me is, well, look, you know, in the elections we just had, Cynthia McKinney won her seat and Sanford Bishop won, so that means that you really didn't need black majority districts anyway. The issue is not whether you elect people who have black faces. The issue is whether you elect African Americans who are independent actors in black interests. That's what the issue is. And we don't have the answer to that in the jurisprudence that is there today. During the Civil Rights Movement, SCLC's motto was to redeem the soul of America. But if America still refuses redemption, I guess we'll just have to figure out some way to save ourselves. And we hope that it will, but at this hour, it is more important than ever that we remain more than one-step thinkers, able to consider more than one approach to problems at the same time, and therefore we ought to understand the uses of law and the uses of Plessy. And what we really ought to do is to follow the example of Homer Plessy and his co-conspirators in 1896, join and support our organizations and each other as if our lives depended on it, because they do. Thank you very much. Thank you. Thank you very much. Thank you.
Now, Dr. Arnold Taylor will make a special presentation.
Those of you who have your packet of conference material may want to turn to the document called Conference Honorees. We have several of them up here today. We had hoped that all would be available for the closing session on Friday from 4 to 6 p.m., but a few cannot. As a consequence, we want to make a presentation today to one of the honorees who cannot remain for the closing session. Some of you may not have the document entitled Conference Honorees, and for that reason, I'm going to read a brief sketch of the person to whom we will make an award today. That person is Jack Greenberg. I'm going to suggest that he sits while we read this, and then we'll invite him to the podium. In becoming Thurgood Marshall's assistant at the NAACP Legal Defense Fund in 1949, just a little over a year after graduating from Columbia Law School, Jack Greenberg began a legal odyssey during which he, and I quote, briefed and argued 40 cases in the Supreme Court of the United States, hundreds in lower federal courts, and supervised a staff of 32 lawyers and about 200 cooperating lawyers in nearly 1,000 cases, unquote. Shortly after joining the fund, he assisted in preparing such cases as Sweat versus Pena and McLaurin versus Oklahoma, collaborated with Lewis Redding in litigating the end to segregation in higher education in Delaware, and again with Redding in arguing before a lower federal court and the United States Supreme Court the case of Belton versus Gebhardt, which involved the desegregation of Delaware's public school system. He also assisted Robert Carter in arguing the case of Brown versus Board of Education at the lower federal court level. Thus, he was a member of Thurgood Marshall's, quote, inner circle, unquote, that prepared and argued the cases that eventuated in the Supreme Court's 1954 Brown decision. He remained a part of the inner circle that litigated various issues flowing from Brown, and in 1961, he succeeded Marshall as head of the Legal Defense Fund. In addition to school segregation cases, his litigation portfolio involved such issues as segregated transportation, employment discrimination, sit-ins, and a variety of civil liberties questions. I might add that I think he would be interested in having us note that he was a lawyer for Mary Berry against Reagan, and he succeeded in getting Mary Berry restored to the United States Commission on Civil Rights. As a lawyer and a law professor, he also became involved in human rights issues abroad. Since 1964, he has served variously as Vice Dean of the Columbia Law School, Dean of Columbia College, and as Professor of Law at Columbia Law School. Mr. Greenberg, would you come to the podium? Mr. Greenberg, we wish to present this award to you. It is called the Carter G. Woodson Award, presented to Jack Greenberg in recognition of your historic role in dismantling the system of racial apartheid in the United States and in furthering the cause of universal human rights. Department of History, Howard University, November 15th, 1996, but this is the 14th, so we can make that little change in the date. Thank you.
I'm certainly not going to keep you here, but I'll just make a few remarks. One is, it's wonderful to be at Howard University again, one of many times I've been here, because this was the cradle of the movement that led to Brown against Board of Education. Second, this award in the name of Carter Woodson is something I particularly cherish because Carter Woodson is someone I knew and who played such an important role in developing black history in the United States. Third, it's marvelous to see my friend and colleague Oliver Hill here, and also my client Mary Berry. Thank you very much.
You may note by the program that Mr. Greenberg is on the program for one of the sessions immediately following our luncheon session. And Mr. Oliver Hill will be attending many sessions, we hope, and we'll have occasion to make comments today and tomorrow. Ms. Debbie Roundtree is a commentator on a session tomorrow. We hope that those of you who are here today will be able to come tomorrow to further the dialogue that is going on. Thank you. Well, Dr. Talbot has told me to tell you that now you can go back to work. So
I wanted to suggest also, there's no harm in giving this man congratulations from time to time if he's in. Thank you very much.